29.
Good evening to all. Welcome to the 4th Professor Shamnad Basheer Memorial Lecture organized by LiveLaw.
29.
Good evening to all. LiveLaw is organizing
this Professor Shamnad Basheer Memorial Lecture organized by LiveLaw.
29.
Good evening to all. Welcome to the 4th Professor Shamnad Basheer Memorial Lecture organized by LiveLaw. LiveLaw is organizing this lecture every year to honor the legacy of Professor Shamnad Basheer, a renowned academic and a great legal thinker who made significant contributions to the field of law within a short span of life. His departure in 2019 was a great professional as well as a personal loss to all Team LiveLaw members. He was a member of our academic council and was a great guiding force, especially in the beginning days of LiveLaw. Professor Basheer was not someone who confined his activities to the abstractions of the classroom. He had an activist zeal and he made certain proactive interventions for the development of law. His interventions in the landmark Novartis case, which is a very landmark case in the field of IP law, is quite noteworthy. Also, IDIA is a brainchild of Professor Shamnad Basheer, and IDIA, all of you must be knowing, is a project which is intended to increase the diversity in national law schools by helping students from marginalized sections to gain admission to national law schools. As I said in the beginning, this is the 4th edition of the memorial lecture. In 2020, we started the memorial lecture, and in 2020, we had Justice Dr. S. Muralidhar, then a judge of the Punjab and Haryana High Court, delivering the lecture. In 2021, we had Justice S. Ravindra Bhatt, then a Supreme Court judge, for delivering the lecture. Last year, in 2022, we had Justice D.Y. Chandrachud, our present Chief Justice of India, to deliver the lecture. This year, we have a very renowned guest to deliver our memorial lecture. I welcome Professor Dr. Mohan Gopal to deliver the 4th Professor Shamnad Basheer Memorial Lecture. Professor Gopal is a very renowned legal academician. He was formerly a Vice Chancellor of the National Law School and also a Director of the National Judicial Academy. And after his stint in the academic field, he has now stepped into litigation as well. So he appears in important, prominent constitutional law matters before Supreme Court as well as High Courts. He made his debut as an arguing counsel in the famous EWS case before the Constitution Bench. He was the lawyer who opened the arguments for the petitioner's side, and he made certain significant arguments before the Constitution Bench. So we are deeply privileged and honored to have Professor Dr. Mohan Gopal to deliver our 4th Professor Shamnad Basheer Memorial Lecture. I welcome you, sir. We will be also having a short interactive session after the lecture. So the interested audience may post their questions in the chat box, and we'll be filtering certain questions, and we'll be having a short interactive session after the talk of Professor Gopal. Over to you, sir.
Thank you very much, Mr. Sebastian, and thank you to LiveLaw. We depend on LiveLaw for our life in law. So, we are very grateful for the excellent services that you provide to us. I also would like to start by paying tribute to the memory of Professor Shamnad Basheer, who was one of the most brilliant young academicians that we had in our country, with extraordinary academic capacity as well as extraordinary capacity for creativity and innovation, for thinking about problems in a new way, developing solutions and implementing them, and achieving results. And I think his loss is indeed an irreparable loss for the legal academy and for the legal system as a whole. And I would like very much to pay my respects to him, and through LiveLaw to his family and to the vast circle of his students, friends, colleagues, and admirers. And so we begin with this tribute, and bearing in mind that what we have to do and what has been done in the last 3 lectures, bearing in mind Shamnad's spirit, is to approach the topic with some innovation and some creativity and think of these issues in a new way. So I will attempt to keep alive the flame of Shamnad Basheer, of thinking innovatively, creatively, and also trying to think about what kind of solutions might solve the kind of issues that we will address during this hour. So thank you very much, and let me now turn to the topic, which is a topic that I suggested to Mr. Sebastian, the Judiciary in a Democracy, Challenges and Opportunities, borrowing from the 16-year-old very successful book of Justice Aaron Barak, former Chief Justice of Israel, who served for nearly 3 decades in the Supreme Court of Israel. He's an academician, has gone back to academics, and he has contributed enormously to reflecting on the judiciary, on justice, on the legal system. So having developed this title based on the title of his book, I think I should start with some reflections of his on this question. Of course, he discussed the judge in a democracy. We are discussing the judiciary in a democracy. And the judiciary is a collection of judges. So it's not any particular judge, but it's the group of judges that exist at any given point of time. But before I turn to Professor Justice Barak, I would like to briefly begin actually with a quotation from a 1986 report of the Law Commission of India, written by another great judge, Justice D.A. Desai, who along with Justice Chinnappa Reddy, Justice Bhagwati, and led by Justice Krishna Iyer, they were known as a gang, lovingly known as a gang of 4, who provided the impetus for a massive change in the judicial system of our country, in the thinking of the judiciary, basically to close the gap between the common people of this country and the judiciary. And I think one of the concerns that prompted me to suggest this topic is a real concern, a question whether that gap is now being closed. And if so, we would be set back by many years. So I think it's appropriate to start with a quotation from Justice D.A. Desai on the issue of the challenge that the Indian judiciary faced at independence. It's not a widely known quote. It's in the 117th report of the Law Commission of India on judicial officers training, which is a very primary guiding book for the judicial academies of our country. Here's a quotation. The Indian judicial system is admittedly colonial in origin and imported in structure. Without even a semblance of change in the last 4 decades, so he's talking about 1947 to 1986, without even a semblance of change in the last 4 decades since independence, in its mode, method of work, designations, language, approach, method of resolving disputes, it has all the trappings of the system established by the foreign rulers. On the attainment of independence, the system was overnight expected to be an effective instrument of ushering in social revolution in Republican India. This is the important sentence. He sees the role of the judicial system as, now it's not a quotation, it's a comment. Justice Desai sees the role of the judicial system as being transformed overnight upon the attainment of independence to become an effective instrument of ushering in social revolution, not social reform or social change, social revolution in Republican India. Democratic India. Republic basically means the rest is owned by the public. It's another way of saying democratic India. On the enforcement of the Constitution in January 1950, this system was expected to adapt itself to facilitate the transformation of Indian society into a nation and to become an effective instrument for carrying out the mandate of Article 38. Again, a comment that this system had a role which is different from which is probably a role that no other system in the world has had. It was unprecedented. On the enforcement of the Constitution in January 1950, the judiciary was expected to adapt itself to facilitate the transformation of Indian society into a nation and to become an effective instrument for carrying out the mandate of Article 38. Thus, from this last sentence, very important sentence, thus from a purely colonial institution, operating more or less as a wing of law and order, as a wing of the law and order enforcement machinery, the judicial system was to become a sentinel on the qui vive, a guardian on the alert, safeguarding democracy. So this is a challenge that one of India's most experienced and respected judges saw and laid down, and it is for equipping the judiciary to be able to meet this challenge of social revolution and building a new social order informed by justice, social, economic, and political, as mandated by Article 38(1), that Justice Desai wanted the judiciary to create judicial academies in order to help the judiciary make this transformation from being a purely colonial institution, which was a wing of the law and order enforcement machinery, in his words, to become a sentinel on the qui vive. Now I turn to Justice Barak, and Justice Barak says, and I'm just reading a couple of quotations, he says, our age is the age of democracy. He writes 16 years ago, our age is the age of democracy. New countries have joined the community of democracy. Many of them wish to re-examine the nature of modern democracy, which is not based solely on the rule of people through their representatives. He calls it formal democracy, but also on the separation of powers, the independence of the judiciary, the rule of law, and, very importantly, human rights, substantive democracy. At a time when we've seen judgments that are taking a much more limited view of democracy as formal democracy, I think it's very important to note the definition of Justice Barak, that democracy also includes not only separation of powers, independence of judiciary, rule of law, but also human rights. And he calls it substantive democracy. And then he says a key historical lesson of the Holocaust is that the people, through their representatives, that is formal democracy, people through their representatives in a formal democracy can destroy democracy and human rights. It's a very important lesson for us to remember at this point, for all of us in the legal discipline, legal profession, to remember that a lesson of the Holocaust is that formal democracy can be used to destroy democracy and human rights. Since the Holocaust, all of us have learned, says Justice Barak, that human rights are the core of substantive democracy. Democracy is not just an add-on, human rights are not just an add-on to democracy. Human rights are at the core of, are the core, not at the core, are the core of substantive democracy. The last few decades have been revolutionary, as we have learned the hard way that without protection for human rights, there can be no democracy and no justification for democracy. This is at a time when apex institutions in our country responsible for human rights are basically deriding democracy. Not only democracy, but also human rights. The protection of human rights, the rights of every individual and every minority group, cannot be left only in the hands of the legislature and the executive, which by their nature reflect majority opinion. So in a formal democracy, we are expecting the majority, says Justice Barak, to protect the rights of the minority. In which case, we don't really, if we had such a majority, we don't need human rights or minority rights. We are living in a perfect society. But unfortunately, that's not the reality anywhere, which is why we have democracy. Demos means common people. Kratos means power. Democracy means power is in the hands of common people. Not that they vote every 5 years, but these are common people who are voting every 5 years in exercise of their human rights. And it is the human rights that they possess that constitute democracy. Without that, there is no democracy, says Justice Barak. Consequently, the question of the role of the judicial branch in a democracy arises. The judicial branch is the judiciary. So Justice Barak says this necessity to protect the human rights of individuals and minority groups is what raises the role of the judiciary in a democracy. Those are almost his exact words. Then Justice Barak says, people increasingly turn to the judiciary, hoping it can solve pressing social problems. Several questions arise. Is this enhanced judicial status appropriate? Have judges taken on too much power? Has the separation of powers become blurred? Indeed, some claim that in recent years, the gap has widened between the practices and public expectations of democratic courts on one hand, and the intellectual normative principles that are supposed to guide the courts on the other. So we expect that courts will be guided by certain normative principles, but Justice Barak 16 years ago was worried that there is an emerging gap between the practice of courts and the normative principles that are supposed to guide them. Justice Barak says this gap is dangerous because over time it will likely undermine public confidence in judges. Because people have confidence not in the judicial system, not just in the decisions of courts, but they have trust and confidence in the normative principles on which the judicial system is built and stands, and which must guide every decision of theirs. Some now argue that judges are too active and the constitution should be taken away from the courts. Others argue that they're too self-restrained. These criticisms come from all corners of society. Such allegations should be evaluated within the framework of a court's role in a democracy. A re-examination is therefore needed, and conclusions must be drawn both about what can be demanded of judges and about what can be expected from the normative frameworks within which they operate. We have to see, are those normative frameworks strong enough? Do we understand what is going on? Finally, the last passage I want to quote is Justice Barak saying, establishing criteria for judging judges is particularly important in view of the frequent attempts to dress up political problems in legal garb and place them before courts. And we are seeing this as a now increasing phenomenon, that political problems are being dressed up in legal garb and placed before the court. Tocqueville, 170 years ago, characterized this tendency to legalize political questions as a quirk of the United States. Today, however, this phenomenon is common in modern democracies. How are we judges, says Justice Barak, to deal with political problems that have taken on a legal character? Now, this is an issue before us because we are seeing an increasing number of issues being put before courts and decisions being taken by courts that raise these very questions. Political questions being put in the garb, dressed up in a legal garb, being put before courts, and then courts taking those decisions. Most recently, we have Article 370, which raised very many constitutional questions, but those questions remain, according to a large number of those who study the Constitution and study the legal system, remain unfortunately unanswered. We've had the Ayodhya judgment, We've had judgments relating to a split decision on hijab, where one of the decisions really said that basically dharma is constitutional law, and questioned the very nature and basis of our understanding of constitutional law. We had the same-sex marriage decision. We had EWS, where, as Mr. Sebastian said, I've been involved. We've had responses of courts to demonetization, and a number of other issues. We've had a series of judgments that have basically restricted the representation of unrepresented communities that could be achieved and was sought to be achieved and was meant to be achieved. We'll come back to this, through reservations in public employment and in the executive, judiciary, and in the legislature. We've had some very controversial issues where there is a sense that the judiciary did not act to protect the interests of the values and norms of the Constitution. We are seeing selective prosecution extensively. We are seeing free speech being attacked extensively. Civil society and opposition being targeted. We are seeing very strong rising Islamophobia. We're also seeing attacks on Christians. The world is saying, international organizations are saying, and we are scoffing at that, but the world is still saying that in indices on press freedom and religious rights, India is now an area of great concern. Is at the same level as notorious dictatorships in other parts of the world. This is something that the government actively denies. Also, in terms of hunger, there is an open assertion of religious practices, of majoritarian religious practices in all spheres, in public functions and public actions, which is converting us not only into quasi-federal, as the judiciary has always described our federalism, but also to quasi-secular. We are being made into a quasi-secular country by the actions of the executive, and for the first time in the EWS case since independence, birth as a Savarna Hindu has given an exclusive privilege to reservation from which Avarna Hindus are excluded. And this is just a fundamental a fundamental practice of Chaturvarnya, to exclude Avarnas and create a space only accessible to Savarnas and others, but certainly not accessible to Savarnas. And there's a long, convoluted legal justification for that. But the bottom line is, you have to be born into a Savarna caste. If you're born into a Savarna caste and you're not part of the creamy layer, you become entitled to reservation in education and appointment. Although there is no problem of lack of representation of the communities from which they come. So we are seeing actually a large number. I'm just picking a few for lack of time, but we are seeing not just judgments, but we are also seeing not judicial activism, but judicial inactivism where there are fundamental attacks being made on constitutional values, and we are seeing no action from the legal system to protect the constitutional values. And we are not fulfilling the role that Justice D.A. Desai, all of us, I take responsibility also, all of us in the legal domain are responsible, and we're not fulfilling the role that Justice D.A. Desai defined for us as being a sentinel on the ki vive. Ki vive means who goes there, who's alive there. Sentinel on the guard, looking out to even guard against attacks which are not yet obvious. So you have to ask, who is there? You have not seen the enemy, and you're still questioning and attacking. Here the enemy is all too obvious, the attack is all too obvious, but there is no response. So in this situation, my next part is how do we understand this problem and how do we go forward? The one way to look at it, which Justice Barak has looked at it 16 years ago in the context of the then prevailing situations, is to see this as, as primarily a question of separation of powers, and to say that his basic message is that judges and the judiciary should be active to protect human rights. That message is more relevant than ever before. But I feel, and I have expressed this once or twice before also, that the situation that we are facing in India is a different one. It is not an issue of separation of powers. It is not an issue of lack of independence of the judiciary. I mean, I have no doubt in my mind that our judges are independent. And they are not, unlike in the early years when we had the emergency and so on, no law minister or no prime minister or no one is dictating to any judge. I'm not saying it happened before, but that's simply not not a question now. We have judges who are very independent and who are acting on their own, and the judiciary is also independent. Why is it that then that the judges are agreeing to sort of dilute the second judge's case, clear primacy of the judiciary in appointments of judges, and allowing the executive to pick and choose, selections made by them and sit on certain other selections? And how are they able to prevent the appointment of several judges who there was no question in the judicial system on the part of anyone, the bar or the bench or the legal academy, that people like Justice Akhil Qureshi, Justice Murlidhar, should have been on the Supreme Court. Justice Sanjeev Banerjee. There are many very independent judges who simply didn't make it to the Supreme Court when we would have had a much stronger judicial system if they had. Now, and there are many others. I just mentioned 2 or 3 names which which came to my mind, but they are not the only ones. There are many others also. So, how is it that these actions are taking place, and there is a sort of a quasi-judicial primacy now, rather than like quasi-secularism, whereas the collegium system was not intended to create a bargaining system between the executive and the judiciary. How is it that these other decisions I referred to are taking place? We can rule out that it is lack of judicial independence, in my view. We can rule out that it is any kind of opportunistic decision making on the part of judges because they're interested in post-retirement positions. I don't think that's the case at all. So then how do we explain this? And I would like to say that what we are now confronting is really part to understand what is going on in the judiciary. Is really we have to look at the larger picture, and we have to understand that there has been a lot of resistance to the very idea of democracy in India. The very idea of demos, common people in India, which is the unlettered masses of this country, that they would hold power effectively has not been accepted by an elite. And this was something that Dr. B.R. Ambedkar warned us about a century ago on several occasions. Notably, he spoke at the first Roundtable Conference in London in 1930, where he said that when the British leaves India, India would be ruled by an aristocracy and an oligarchy. Aristocracy doesn't rule, an archy is ruled. So an aristocracy would rule as an oligarchy. And that's basically what's happened. A small number of communities, the composition, the membership of the oligarchy changes from state to state and at the national level. But at any part of India, we have power concentrated in a few communities. And And if you look at the national institutions, if you look at public employment, you look at the legislature, you look at the cabinet of the country and of the states, if you look at the private sector, media, academia, you find that 3 or 4 communities, not more than that, basically dominate those institutions. It's like one retired judge from the Kerala High Court publicly spoke, speaking at a community function of his, and said, look, he's not in favor of any community sort of, being appointed or not appointed, but he basically described his own community's culture. You must be vegetarian and blah, 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 so many things. And he said, only people with these characteristics should rule the country. So we could understand it not really as casteism, but as an elitism, as an oligarchic elitism, that there is a feeling that people with certain qualities are the elite, and those elites must rule. And by coincidence, you have to be born into those cultures to acquire, into those communities to acquire those cultures. And in a country that is so large and so huge, that I'll just point this out. This is kind of well known, but I took this data out. If you take the 10 most populous states of India, there are about 1 billion people, right? And if you match them to the population of other countries, we'll say that we will understand we have about 15 countries inside this, in these 10 most populous states. So UP is as populous as Pakistan. Bihar has the same population as Mexico. Egypt has the same population as West Bengal. Mexico has the same population as Maharashtra. Turkey has the same population as Madhya Pradesh. Germany has the same population as Rajasthan. France and Belgium combined have the same population of Tamil Nadu. Spain and Norway combined have the same population as Andhra Pradesh. Karnataka has the same population as the United Kingdom. Italy and Sweden have the same population combined as Gujarat. This is just the top 10 states, and that's 1 billion people. And the remaining half a billion people have the same population as that of the United States and Russia combined. This is India. And the diversity and differences and cultural richness and variety and traditions of these countries that are contained in this magnificent, glorious country of ours called India is even more diverse than the countries I've named. Now, to think that anyone can say there must be one election, one government, one ruler, one system, one religion, one way of thinking, one culture, one philosophy, I think is asking for the impossible. It is a recipe for nothing but splintering and fragmenting our country, which is why the Constitution of India Constituent Assembly of India unanimously formulated a constitution which was intended to keep us together, so that the slaughter of 1947, where we fought over religion and tens of thousands of Indians killed each other, would never happen again. And this can happen only through, India can be preserved only through substantive democracy. And at the core of substantive democracy, to quote Justice Barak, are individual and human rights of individuals and human rights of minority groups. Without this, India will not survive. There's no doubt about it. Anyone who is committed to preserving this republic, this country, and taking it to greater and greater equity and prosperity, have to accept that these fundamental human rights that are in our Constitution of equality, liberty, dignity, fraternity, are as essential for the survival of our country as oxygen and water and food is for the survival of a human being. And this is what Justice Barak tells us, that that democracy is not a luxury for us. Human rights are not a luxury for us. We cannot, with all these in a land populated by diversity and population sizes of all the countries that I just described, we can only stay together on the basis of power being vested in common people at the grassroots and then being exercised through elected representatives. So Dr. Ambedkar said in 1930 to the first Roundtable Conference that he has certain demands for the depressed classes, and he gave in a memorandum with 8 demands, 8 safeguards, 8 conditions. Conditions 4 and 5 were about representative government. Before that, he said, everyone who has come from India, including us, two people represented the depressed classes. He said, we have come here to demand responsible government, that is, government elected by the people. But he said the depressed classes want something more, which is equally important for them, and that is representative government and representative democracy. That demand was accepted and acted upon maybe not in exactly the way Dr. Ambedkar wanted, but that forceful demand that he made had to be accepted, and it survived into the Constitution briefly as 16.4, which talks of adequate representation. Reservation to ensure adequate representation. It also was very strongly a part of the Minorities Committee report presented by Sardar Patel in 1947. And in the document that Sardar Patel, in the letter that he sent to the Constituent Assembly submitting the Minorities Committee report, he emphasizes that the 2 minorities that are above 2%, namely scheduled castes and scheduled tribes, 1, and Muslims, 2, must have or will have reservation in the legislature. There was a demand that they should have reservation in the cabinet, and Sardar Patel said, while we do not want to have the rigidity of reservation in the cabinet, we will put in the Constitution an advisory that these minorities, all minorities, but particularly these minorities, that when the governor invites a person to form the government who has a majority, the governor will advise the person to ensure that there is adequate representation in the cabinet for Muslims and scheduled castes and scheduled tribes. These were the assurances after the partition, after independence, on the basis of which this republic was knowingly and deliberately formed, because we know that our survival depends upon the protection of human rights and minority rights. And so Dr. Ambedkar put these demands forward and demand for representative democracy. But the story we've seen is that both democracy and representative government has been systematically undermined and is systematically narrowed, and is increasingly being replaced by top-down, elitist, authoritarian, oligarchic government, which in order to stay in power has to employ tools of coercion, because you're not ruling by consent, you're ruling by coercion through use of police power. And we are seeing in the new criminal law bills a significant enhancement of police power and the vulnerability of people who do not agree with this majoritarian view of facing severe action to silence them. And so this is the larger context going on here. So on one hand, we have a struggle for a democracy which is a substantive democracy, not just a formal democracy. The democracy envisaged in the Indian Constitution is a substantive democracy. At the center of it is Part 3 with fundamental rights, Part 4 with directives and principles of state policy on social and economic aspects. As I said, Article 38 saying that the state shall promote the welfare of the people by ensuring as effectively as it may, securing as effectively as it may a social order in which justice, social, economic, and political shall inform all institutions of national life. These are pillars of a substantive democracy. So we have a constitution. On one hand, we have a vision of a constitution with substantive democracy, to use Justice Barak's term. On the other hand, we have a vision, right for a century now, that India must be molded around what I call the H cubed or 3H principle. Hindi, Hindu, and Hindustan. Hindi as a culture, Hindu as a religion and a way of life, and Hindustan as a Hindu Rashtra. So this is these are the two competing ideas of India now that are and the battle for this has become serious, because those who believe that India should be not a substantive democracy but should be a republic, sorry, not a republic but in fact the original authors of the H3 view believe it should be a monarchy, but it certainly should be a polity based on this 3H formula of Hindi, Hindu, and Hindustan. And they have actually acquired power over the union, and they are deploying that power to undermine democracy and to take forward this agenda. Now, last point, and then we'll stop and have 15 minutes for discussion. The challenge of the judiciary, not just the opportunity, but the dire need for the country, is for the judiciary to protect the constitutional vision of substantive democracy, and to recognize that what is happening in this country in reality is an attempt to establish an H3 polity in our country, which is incompatible with substantive democracy, which is anti-democratic, anti-secular, anti-socialist. Socialism being used not in the Marxist sense of the word, but in the broadest sense of that word, as being a system. Socius means friend, where there is a system of fraternity, where there is a fraternal population. So this is what is going on here, and the problem is that as individuals, based on their own background, not based on speculation about their personal views, but their own career track, there's an increasing number of judges who have in their earlier parts of their career have been committed to this other view of what India should be like, that it should be based on Hindi, Hindu, and Hindustan. And there are lawyers who believe in that, not just judges. There are lawyers who believe in that. And of course, there are important officials who believe in that. There are academics who believe in that. There's a wide section of people who believe in that. They all belong to these oligarchic communities, and they fear democracy, because in a democracy with proportional representation, they will have their due share. They must have their due share, but only their due share. And power will be scattered. So Dr. Ambedkar saw representative democracy as an antidote to oligarchy. They cannot coexist. If you have representative democracy in a diverse country, oligarchy will be instantly ended. And therefore, these two visions are colliding. And what we're dealing with here is not a dishonest or opportunistic use of judicial power or executive power or legislative power. We are seeing a bona fide use of judicial, executive, and legislative power in order to take forward a vision that those who believe in it believe it's the best for this country. They genuinely believe it's the best for this country. They have no wrong intentions for the country. They believe it's the best for this country. But it's not the vision of our Constitution. So they are trying through interpretation and through various decisions to sort of working around the edges of the Constitution to develop an alternative understanding of the Constitution, which will be consistent more with their view than with the view of substantive democracy that Justice D.A. Desai and various other judges of our country and Justice Barak and so on talk about. This is also xenophobic. There is a sense of, this H3 agenda always asserts that the Hindu culture is superior to all other cultures and everyone has to accept it. All cultures are great. All cultures are rich. They all have their problems. They all have their good points and their bad points. That's a realistic view. But somehow there is the supremacist view and a hegemonic view, which is all very dangerous. The H3 agenda may be acceptable to the Hindi-speaking North, but it would be very difficult for non-Hindi speaking, especially southern states, to accept it, which is why there is difficulty in getting electoral acceptance for this agenda below the Vindhyas. So in this context, what should the judiciary do? I think they should just remember their oath, their constitutional oath. And they should read it carefully, in substance, not just in letter. I'm not saying this as to be patronizing or give any advice. It's just a hope that they will read their oath, because the oath is very interesting. Only the judicial oath, which is also the CAG's oath, only the judicial oath has, I won't waste time bringing it out, but only in the judicial oath it says not that they will just uphold the Constitution, that the judges have faith in the Constitution. Faith. Faith in religion, faith in the Constitution is a very high standard. Once you have taken a sworn an oath that you have faith in the Constitution, it means you have faith in human rights, your faith in democracy, your faith in secularism, your faith in socialism, in equality, in liberty, in fraternity, in individual dignity, your faith that the Varnashrama system is wrong, that there cannot be a hierarchical division of human beings, that all human beings are created equal. Your faith that there cannot be xenophobia, that we are all one humanity. Once you have sworn that you have faith in that, then I think we would expect, I have no doubt that the judges, once they're reminded of that, would live up to that oath and live up to that faith, and that will be reflected in their decisions, and they would take an active role in protecting our democracy, our substantive democracy. And this is not the time to discuss individual cases, but certainly if we go to individual cases, we can see how a formal view of democracy has won over a substantive view of democracy. For example, in 370, what was not, I don't think, discussed in the judgment, I don't think even in the arguments, was what was involved was the human rights of individuals and minorities in Kashmir. That had to be safeguarded. The rest are simply mechanisms for safeguarding those rights. But ultimately, what was at issue was the human rights of the people. And representatives at the local level, at the state level, the national level, parliament, executive, judiciary, to protect those rights in a democracy. But that has been forgotten, seems to be, or at least not discussed explicitly. And that is what we need to remember. And we need to not let formalistic approaches to democracy, important as they are, essential as they are, lead us to neglect and forget the substantive parts of democracy. So let me conclude here by saying that the challenge and the opportunity for the Indian judiciary, the judicial system, the collection of judges, and for the bar, and for legal academia. I just spoke 2 hours this morning to a program of, training program for law teachers from 28 states. And so we are all in this together, the entire legal profession. Our job is to ensure that, as Justice Barak said, and I will conclude with that, he said, the two responsibilities of judges, he says, are number one, protect the coherence of the legal system. Protect the coherence of the legal system. And the second is to defend the Constitution and protect democracy, substantive democracy. So I think we have a very clear consensus, a very clear view of what is necessary. And I've no doubt that at the end of the day, there are many good decisions as well. At the end of the day, a consensus will emerge in the legal community, all of us together, and this will be reflected in the judiciary, that our job is to protect the Constitution and defend democracy. Thank you very much. You're muted, I think.
Thank you, sir, for your enlightening session. We have got a few messages regarding questions. So one viewer has messaged. So you have mentioned in your lecture about political questions being dressed as legal issues and being presented before the court. And so in many cases, we have seen the court adopting a very stretched interpretation to favor the government stance. And this happens mostly when there is a majoritarian government in force. This we witnessed during the emergency time as well as the present times also. So why do you think this is happening, and what could be a remedy for such situations?
See, I think we are facing from the point of view of the role of the judiciary. Otherwise, there are many similarities. I think the new criminal bills normalize emergency powers in the police. So there are many similarities. But the role of the concerns about the role of the judiciary and the legal system, I think today are very different from that of the emergency. Emergency, the challenge was really lack of independence of the judiciary. Judges were being, pressure was being put on the judges to do as the executive wanted. Now there is no need for that. Not that the executive won't do that. There are the executive and a segment of the legal profession and the legal system and the bar and the bench. They're all in agreement about which direction this country should go. There is no need to put pressure. This is what is now going on. It's an ideological battle. The emergency was a battle for power. And also there was an ideological context. But this is primarily an ideological battle to make India this 3H republic. So I think we have to understand that what is going on today is qualitatively different as far as the judiciary is concerned. The judges are acting independently. But what view are they taking of the Constitution ideologically? Are they seeing any legitimacy for this Hindi, Hindustan agenda? Are they seeing any legitimacy for this top-down agenda? Do they see any problems with this bottom-up approach to democracy? That is our Constitution, where power goes to the poorest people, where individual rights and minority rights are protected. That, I think, is the issue. So here, political issues are, I find, take the Ayodhya judgment. It was not decided for a long time. But finally, for example, if you look at the addendum of the judgment, we don't know who wrote it, and it was put as after it was put after the signatures by the judges, so we don't know what its real status is. But it's an enthusiastic addendum, which is religious in nature. And it I think came from the heart of one or more judges who wrote it. When, as I said, one of the judges in the hijab judgment says that dharma is constitutional law. When he says dharma, he means obviously there is only, I assume that the reference is to Sanatana Dharma, not to Islamic Dharma or Christian Dharma or some other Dharma. This is from the heart. This is not, no pressure is being put on any of this. This is the belief of the judge, and they're entitled to that belief. And it's a bona fide belief. They believe that that's what will take the society forward. But that's not the vision of the Constitution. So there is a disagreement with the Constitution. This is the best comparison. Is we are in this similar situation as the United States just before the Civil War. By the way, the United States had its Civil War in the 8th decade of its independence, depending on how you count. We are in the 8th decade of its Constitution. We are in the 8th decade of our Constitution. And so in that situation, the United States Supreme Court, by majority judgment, upheld slavery. Not because any pressure was brought on it by Lincoln, who was then the president, who was against slavery, one way or another. But the judges believed that slavery was right, that slaves are only property. They believed that, and they believed that that view was essential for the well-being and future of the United States, until Lincoln said this nation cannot exist half slave and half free. He said that it is democracy when a white person is ruled by a white person, but it is despotism when a black person is ruled by a white person. Similarly here, when oligarchy rules the common people because they're supposed to be dumb and illiterate, that's despotism. It's not democracy. So we are dealing with a very different situation where there is a genuine viewpoint that this Hindu, Hindustan is the right way for India to move forward based on all Vedic values. And so, yes, the lines between legal and political issues are being blurred constitutional political issues are being blurred. And the advantage of taking a decision in the court is that there is no appeal from the Supreme Court. There is no public debate. Only limited number of lawyers for a limited number of minutes can argue. Whereas if you argue in Parliament, you argue in the legislature, it becomes a much more complex issue. So, so it's just an easier way of moving the country to a Hindustan platform than it is done doing it through the political process. So I think we must recognize that this is a very different scenario, and we as legal people must resist the political issues being decided through the judiciary, simply because it does not allow the same type of access to argument and debate and democratic decision making that the legislature allows.
So what you're suggesting is that judges are favoring the executive position in most cases, not out of any pressure or any coercion, but because they are inherently ideologically aligned with the government.
See, I would not put it in terms of government or executive. There is a group of Indians who believe that there is a certain good way forward. And there is another group of Indians who believe that India must be ruled bottom up and democratically. There is another group of Indians who believe that an oligarchy that has been ousted from power by Mughals and various Muslim rulers and British and Christians and all that, now it is there. They must now take the reins of India and take India forward to its Vedic destiny, right? They believe that. Now they are in government, they are in the legislature, they are in the judiciary, they are in business, they are in academia, they are in media. They are everywhere, but they believe that, and they are doing what they can to take forward that mission. And they don't agree with the view of the Constitution. So we cannot look at it simply as government and executive and judiciary and so on. There is a powerful group of people who are part of the oligarchy or sympathetic to the oligarchy that rules us, as to use Ambedkar's term. And they are now in control of the steering wheel, and they want to take this to a new destination, this country. And that's how if you understand the problem, then we have to say, look, we have to be vigilant about this. I call this kind of judging, not judges, but I call this kind of judgments theocratic judgments that are based upon the idea of some sort of religion-based ideas outside the Constitution. So that the theocratic policies coming from the government, theocratic judgments coming from the judiciary, theocratic laws coming from the legislature.
Okay, sir. So now moving on to another question. So this is regarding the judicial appointment process. Since yes. Despite the collegium, despite the Supreme Court judgments, the central government is actively sitting on collegium recommendations and splitting up collegium recommendations and selectively doing yes. pick and choose. So by doing this process, the center is actually ensuring that judges who are favorable to the government are getting appointed. So how do you ensure judicial independence in such a background?
No, I think, again, I would say the same thing. I won't repeat myself, that the question is, there is the collegium seems to be open to a conversation with the government on who to pick and who not to pick, because which is not envisaged in the second judge's case. I don't think it's a question of government or non-government, but those who are those who believe that the government has a legitimate, that the ultimate ideological goal of the government is legitimate, but they may disagree on strategies: A, the best person; B, the best person; C, the best person. They are willing to have a dialogue with them. But if you feel that the government's ideological goal, that those who are in power, their ideological goal is anti-constitutional, anti-national, then you're not prepared to have a conversation with them, right? You're going to say, look, we are constitutionalists. We will pick people who will ensure that the Constitution is the last word, the Grundnorm, and all power and authority comes from the people, and we believe in democracy, and they will safeguard and protect democracy. Right? Then there is there's no question of allowing a government that avowedly, openly They come from a movement that has for 100 years said we want to establish a Hindu Rashtra in this country. They've never disavowed that. So, so if you believe that that is not an acceptable objective, then there's no question of conversation with the government. You say, we have the last word. This is who we have selected. You appoint them. If not, you're in contempt of court.
So another question is it a good idea to have a proportional representation in higher judiciary based on the population of different states and linguistic and religious groups to ensure more diversity?
The short answer is yes. It is necessary, not just a good idea, it's necessary. So I'll tell you, if we had a Supreme Court with due and adequate representation of all communities, this is what the words Ambedkar used, Dr. Ambedkar used, then we would have 8 scheduled caste and scheduled tribe judges in the Supreme Court. Right? We would have 5 minority judges in the Supreme Court. We would have 20, Panchama judges in the Supreme Court, and we may have one Savarna judge. Now these numbers are not quotas. We may have 3 or 4 Savarnas and so on and so forth. But if you had, and 50% of this or more would be women. Right? Now, if you had 8 scheduled caste and scheduled tribe judges in the Supreme Court, do you think the jurisprudence of the Supreme Court would be different, or would it be the same? See, that's a diversity that the United States Supreme Court insisted upon when Justice Stephen Breyer retired. They said, we want a black woman. We already had a black man, and blacks are only about 12% of the population. They said, we want not only a black man, we want a black woman. And they appointed a black woman. We have now 4 out of 9 judges are black women, and not a single judge of the US Supreme Court was born into what they consider their majority community, white Anglo-Saxon Protestant, right? So that's their concern about diversity. Why? Because we want a jurisprudence to emerge from the court that reflects the diversity, different kinds of minds and attitudes. They're all competent, all honest, all independent, all good, but they are different human beings and they're shaped by their own experience. So when we have diversity, we have a more inclusive, a more representative view of the country sitting on the court, and that's what other courts want in other parts of the world, and we must have that in our Supreme Court. I'm not saying we must have precise quotas and so on, but a representative, diverse judiciary is important. And the Chief Justice of India, Mr. Justice D.Y. Chandrachud, has I think taken this view. If I've read in the media, he has also taken the view that we need a representative and diverse judiciary, and I totally agree with him.
So, sir, thank you so much for delivering this lecture and sharing your insights about judiciary and our democratic situation. Thank you so much.
Thank you very much for having me. And once again, we remember and pay tribute to Professor Shamnad Basheer as we end. Thank you so much.